tonight on governance issues is Dan Pinnington from Law Pro.
I always like speaking engagements that are in the evening and just 2 subway stops from home. I am not Ukrainian, but living in this neighborhood, I think should count for something. My topic was to be risk management issues to consider when a lawyer is sitting on your board. But I thought that might be fairly narrow and speak only to the lawyers in the room, and I know we have a bunch of folks who are not, in fact, lawyers. So I've changed my topic up a little bit to kind of ask the questions someone should consider if they were considering on a board, sitting on a board, lawyer or non-lawyer alike. Now, general comments, given the short time slot, I think you'll find that much of what I say has been echoed in what the other speakers have already said tonight. Serving on a board of a not-for-profit or charity organization can be very rewarding. Of course, there is a benefit to the organization, you offering the special expertise that you bring if you're a lawyer or accountant, that kind of expertise, but generally any other board member brings something to the table, something that they can contribute. It's a way from a personal level that you can commit or contribute to a personal cause. It's a way to give something back to a community that you care about or would like to support, and of course it's also probably an opportunity to directly or indirectly market your business if that's of interest. But more importantly, or the issue that I'd like to highlight, it's actually also an activity that can bring some potential risk, because you can be held personally liable for the work that you or others on the board do or don't do, the admissions of others. And that liability is actually joint and several, meaning that if you've got the deepest pockets on the board and other members of the board are other members of the board are sued along with you, and there's a judgment there, and you've got deeper pockets, you're liable. So I'd like to run through the questions you should ask if you are going to sit on the board. First of all, how well do you know the organization? Have you sat down and done some research, looked at their website, more importantly, looked at the articles of incorporation and the bylaws, looking at any annual reports, understanding, are they operating well, are they transparent, and so on. Does it engage in activities that may expose you to liability, or that might attract higher than usual liability? The usual example that's rolled out there is some kind of a sporting or athletic organization where coaches may be potential liability in terms of a situation where there's sexual assaults. But we've also heard earlier tonight, any organization that has significant assets, there's potential exposure there, in particular if there's a fraud. And echo the comment earlier tonight that frauds very often involve internal folks, and it's often people who have some kind of personal issue that drives them to need money, and they'll dig into finances. HR and tax liabilities are other examples there. Second question to ask, do you understand the responsibilities that you take on when you sit on a board of directors? A bit of legalese here, but it's fairly plain English, so you should all understand it. In discharging duties to a corporation, every director and officer shall, and this is language right out of both the provincial and federal legislation governing corporations, act honestly and good faith with a view to the best interests of the corporation. Now, in law, there's complex case law and everything that backs up what those statements actually mean in practice, but a pretty plain English reading of them indicates what they really mean. You must also exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. So the reasonable person is kind of standard. And again, that's a very technical legal argument if you want to go and argue that before the court, but I think you all understand the plain wording of there. Secondly, recognizing the duties that you take on, do you really have the time to commit the effort to make sure that you fulfill those duties? We've all been on boards where there's a member who's there and not pulling their own weight. Okay, next up, I have bad news and good news. I'm going to deal with the bad news first. There are a number of statutes that impose liability on directors. Any guesses on how many? I'll throw some numbers. Higher. There's about 200 statutes, provincially and federally, that impose liabilities on directors, and there's a further 100 statutes that impose liabilities on the officers of an organization. Some bunch of examples that have already been mentioned tonight. Different taxes, the Employment Standards Act, Retail Sales Act, some of the environmental statutes can impose significant obligations and fines. Now, admittedly, some of these are fairly remote, but they are there, and they may come into play depending on what the organization is doing. So something to think about. Okay, now the good news. Not all, but a significant number of those statutes which impose liability allow a director to avoid negligence if they can show due diligence, the defense of due diligence. I made efforts to understand or deal with a particular situation. Now, a bit of legalese here, but again, it's all fairly plain English. You must demonstrate that you use the care, diligence, and skill that any reasonably prudent person would have used in comparable circumstances. So again, that's what we call the reasonable person test. How do you do that? You show that you act reasonably at all times, that there were adequate controls in place, that if any problems came to your attention, you stepped up to the plate and made sure that they were dealt with, that actions taken were documented, and that there was a regular kind of report to the board from the staff of the charity so that you were fully informed, properly informed of what was going on. There's another wrinkle that can get you off the hook, and that was mentioned earlier tonight as well. You can rely on the advice of outside experts. So the lesson there is if there's something that no one on the board understands, or a particular issue that appears that it could have significant implications, go out and get the expertise that may be. That may be a financial expert, a legal expert, or some other person with some other expertise. Secondly, or thirdly, if you disagree with the course of action the board is taking, make sure that you register your dissent. That can be a protection in some circumstances, and typically that's done by making a notation in the minutes. And beware that lack of knowledge is not a defense. So if you happen to miss a meeting, you're actually deemed to have adopted everything that was decided at the meeting as a director. Again, a lesson to go back. If something was decided that you don't agree with, make sure that your dissent was registered. Okay, recognizing that there are some dangers there, what are some of the steps you can do to reduce those dangers beyond the due diligence offense? First of all, see if the organization will indemnify you for any potential exposures. Most major charitable organizations will actually sign an indemnity agreement, which is basically a contract they enter into with you that say, we will protect you if you're sued personally for the work that you are doing on our behalf. It's a formal contract between you and the organization. And not only will it cover the damages that might otherwise come from you being sued due to some shortcoming alleged by the corporation, importantly as well, indemnity agreements will also cover defense costs of defending you if there is an allegation even a baseless allegation can take considerable time and effort, involve litigation expenses can be considerable. So that's important to have a litigation or an indemnity agreement. Beyond an indemnity agreement, for extra protection, lawyers, firms sometimes will have extra insurance in place to cover the work that their lawyers do as outside directors. So something to look at. Directors and officers, sorry, the organization will have directors and officers insurance. Something to look at as well. If there is insurance, D&O insurance there, we'll look at it. What are the policy terms? Understand what's there. So specific comments to the lawyers and other professionals in the room. Ask yourself, does your firm have a policy with respect to you sitting on the board? I know many law firms have a policy. Frankly, in my experience, the policy is there and people don't look at it, but you should at least ask the question, does your firm ask for that you inform them that you're, usually it's inform them that you're sitting on a board so they can take appropriate steps and add you on any outside insurance policies and so on. Secondly, in particular, some firms have a policy that says if the charity is a client of the firm, that you can't sit on the board, and that's simply recognizing the fact that there's potential of conflicts of interest there at a bunch of levels, and many firms will say, no, you can't act. In some cases, they will allow people to act if it's a very large charity and there's work being done on a pro bono basis or something like that. Next up, lawyers or other professionals on a board are held to a higher standard than regular members of the board. If you're there and you have legal knowledge, or you're an accountant and you have professional knowledge or accounting knowledge, you're held to a higher standard with respect to the communications that you give to a board. So something to remember there. For the lawyers in the room, note that the Law Pro policy only covers you for the work that you do with your legal hat on. That is the professional services you provide to clients, whether they're paid or pro bono clients, with respect to the laws of the Dominion of Canada and its respective parents or provinces. If you are providing advice for foreign law, that's not covered under the policy. If you are otherwise on the board giving some advice or direction on a non-legal issue, that would not be covered under your Law Pro policy. That's what the other insurance policies that you should look for. And CBIA, the Canadian Bar Association, actually has an excellent policy for that. If you can talk to your insurance broker, otherwise, to find that coverage is available elsewhere. Also, excess policies, the Law Pro excess policy does not cover director and officer work. Some of the excess policies that some firms have drop-down coverage and excess coverage for a director and officer kinds of issues. I guess hopefully after everything I've said tonight, I'm not going to scare you all into resigning or not signing up on a board. It is otherwise can be a very rewarding experience both for you. It's a way to give back to an organization and to a community. Just beware of the risks